Morning, everybody. When we finished last night, I'd heard submissions from those representing the bereaved, survivors and other local residents, and we've now got to the stage at which I would invite Mr. Maxwell Scott to say something on behalf of the Council. Thank you.
Mr. Chairman, I'm James Maxwell Scott and I represent the Royal Borough of Kensington and Chelsea, instructed by DWF. Before turning to some specific topics, I would like to make some introductory points. We have listened very carefully to the submissions made yesterday on behalf of bereaved family members, survivors and former residents. Many valid points were made which seem to us to derive from two central themes. First, the centrality to this inquiry of the bereaved, of the survivors, and of the former residents. Secondly, the importance of transparency. RBKC respectfully agrees with the importance of both of those themes. Sir, you and many others present today may already be aware of the resolution adopted by the full Council at its meeting on Wednesday, the 6th of December, but I hope that you will forgive me reminding you of it. The subject matter of the resolution was the report of Bishop Jones, which was referred to in some of yesterday's submissions. The resolution was proposed by the leader of the Council, Elizabeth Campbell, and passed unanimously. The full text of the resolution can be found on the Council's website, but I hope that it will assist if I read some extracts from it. The resolution began by stating, "This Council notes the publication of the report by the Right Reverend James Jones, Bishop of Liverpool and Chair of the Hillsborough Independent Panel." It also stated, "In line with the report's recommendations, this Council reaffirms its commitment to be open, transparent and fully cooperative with the public inquiry into the Grenfell Tower fire, the inquests into the deaths in the fire and the police investigation." The resolution went on to set out 6 numbered commitments, of which I will read 3, if I may. We commit to the Royal Borough of Kensington and Chelsea becoming an organisation which strives to place the public interest above our own reputation. We commit to the Royal Borough of Kensington and Chelsea becoming an organisation which strives to approach forms of public scrutiny, including public inquiries and inquests, with candour, in an open, honest and transparent way, making full disclosure of relevant documents, material and facts. Our objective is to assist the search for the truth. We accept that we should learn from the findings of external scrutiny and from past mistakes. We commit to the Royal Borough of Kensington and Chelsea becoming an organisation which strives to avoid seeking to defend the indefensible or to dismiss or disparage those who may have suffered where we have fallen short. So I now turn to my submissions on specific topics. I have 3 topics which I wish to cover, and they are disclosure, experts, and the split between Phase 1 and Phase 2. Turning first to disclosure. So, as you will have deduced from the resolution passed by the Council last week, we are sympathetic to the submissions made yesterday about the importance of a disclosure process being transparent and of the need for participation to be informed by disclosure in order for it to be meaningful. RBKC received a detailed request for disclosure from the solicitor to the inquiry on the 24th of August. We have provided your team with disclosure in response to that request and with a signed disclosure statement. That disclosure statement, dated the 8th of November, runs to 52 paragraphs plus appendices, and you will probably be pleased to hear that I do not intend to read all of it into the record. However, it may assist if I refer to a small number of paragraphs from it, because they may help to answer some of the questions raised entirely legitimately, yesterday. RBKC received notice from the Metropolitan Police to retain all data across its servers on the 20th of June. RBKC's Shared Information and Communications Technology Service Infrastructure Manager ensured that, upon receipt of a letter, all data held on RBKC's storage area network was duplicated to create a stable copy, meaning that the data could not be changed or modified. The amount of data preserved in this manner was around 80 terabytes in total. DWF, through their forensic services providers, began extracting documents from RBKC servers on the 3rd of July. The data was processed, then added to an online review platform, Relativity, chosen by DWF for, amongst other reasons, its advanced service searching capabilities. Subsequently, a large number of documents were uploaded onto Relativity. By the 8th of November, 1,516,427 documents have been uploaded onto Relativity. DWF and their forensic services providers can confirm that no documentation has been redacted, altered, or tampered with in any way since being received by DWF or their forensic services providers. And so, pausing there, I can state that all of those 1.5 million documents have been disclosed to the police. So, returning then to how disclosure has been given to your team, those documents were searched electronically by running keyword search terms across them. The search terms used have been provided to your team in an appendix to the disclosure statement. That process resulted in 90,563 responsive documents. The team was then set up manually to review those documents, and the disclosure statement explains the nature of the team and how it worked. The outcome of the manual review process was that 12,918 documents were disclosed to your team by the 8th of November. The concluding section of the disclosure statement addressed the ongoing duty of disclosure. It stated, DWF and RBKC understand that they have an ongoing duty of disclosure to provide the inquiry of documents identified after the 31st of October as being relevant to the request. It concluded by stating, DWF and RBKC understand that the inquiry may request that further searches of Relativity be carried out using additional search terms notified to them by the inquiry. DWF and RBKC also understand that the inquiry may request additional information beyond that identified in the request. DWF and RBKC will cooperate fully with any such requests from the inquiry. So you've heard me refer to our disclosure statement and to endorse the importance of transparency in the disclosure process. We are conscious that we are just one of 31 document providers, and therefore we leave it to you and your team to decide how best to achieve greater transparency in this important area. I can take my remaining 2 points more shortly. Firstly, experts. So you have my submission that it would greatly assist all call participants if expert reports could be provided sooner than 1 month before the start of Phase 1 evidential hearings. And I don't propose to expand upon it further here. And my final point, the Phase 1, Phase 2 split. As indicated in my written submissions, we recognise that the views of the bereaved, the survivors, and of the former residents on the timetabling of Phase 1 and the Phase 1, Phase 2 split are of primary importance. There's no perfect solution to this because some issues inevitably have the potential to overlap between phases. At this stage, I will restrict myself to the following general points. By the time Phase 1 starts, there needs to be clarity as to which issues will be addressed and whether any views expressed on them in an interim report will be provisional or final. these issues need to be clarified in sufficient time to enable all core participants to prepare for phase one. Of course, some residual flexibility will need to be retained. Fairness to all core participants must be ensured. So we noted Mr. Friedman's submission that provisional recommendations could be made before the end of phase one, and we respectfully agree. If at any stage you reach a point where the information you have received leads you to consider that you should make a safety critical recommendation as a matter of urgency, you can, after inviting and receiving submissions, make it, and in appropriate cases should do so. So unless I can assist any further, those are my submissions.
Well, thank you very much. Could I trouble you perhaps on two matters which arose in the course of submissions yesterday, on which you, as an important core participant, may or may not have a view. One is the establishment of what I think we've called a consultative panel. This was something I suggested, I think, to Mr. Mansfield in the course of his submissions. Do you have any observations to make on that?
Certainly have no objection to that. It seemed a sensible suggestion.
All right, thank you very much. The other matter was a suggestion which I think may have come from Mr. Weatherby, I can't quite pin it down, which was that we might invite some people to provide position statements, and I think the Council would probably be one party to whom such a request would be directed. Do you want to say anything about that? Is it a good idea, or?
I will say something about that, sir. The inquiry rules permit core participants to make an opening statement and a closing statement, as you know. Unless you direct otherwise, it would be my intention, on behalf of RBKC, to make an opening statement and a closing statement. Those opening statements will assist the inquiry and other core participants by setting out RBKC's position on a range of issues. Of course, if you consider it would be helpful to have an indication of RBKC's position before the start of phase two, on phase two issues, you have a number of options. You could direct written phase two opening statements be provided in advance, or you could direct something very similar but call it a position statement. We wouldn't in principle object to such an approach. I don't know what timing is being considered, but we would submit it would be premature to order position statements now. If position statements are to provide you with real assistance, there will, as a minimum, we suggest, have needed first to be meaningful disclosure in relation to the issues, sufficient time to analyse the relevant documents, probably sight of relevant expert reports, and time to take instructions. But we're certainly not opposed in principle.
All right. That's very helpful. Thank you very much.
Thank you.
Now, the next speaker on my running order is Ms. Jarrett. Yes.
Mr. Chairman, I am Alice Jarrett and I appear on behalf of the Kensington and Chelsea Tenant Management Organisation, the TMO, and I'm instructed to attend today by Kennedy's solicitors. The TMO recognises how important it is that this inquiry takes place, to understand not only how this terrible tragedy came about, but also to identify the steps to ensure that it never happens again. The TMO have engaged fully with the inquiry process thus far, and it wishes to encourage transparency in this process. And we will continue to assist the inquiry wherever possible going forward. The TMO is a resident-led organisation with a majority of local tenants on its board. They are accompanied by council-nominated and independent directors. It deals with the estate management of approximately 10,000 properties within the council portfolio, including the Lancaster West Estate and, of course, Grenfell Tower. In relation to our written submissions and turning to those, they relate only, of course, to the timings of service of the inquiry's expert reports, and we echo the oral submissions of those who have gone before us that there must be prompt service of these reports to allow for their content to be properly considered by the core participants. We welcome Mr Millet's of Queen's Council's acknowledgement in his opening yesterday that it is right that the timescales for service of such reports and any responses are carefully considered, and we too ask for proper time to review that disclosure. In respect of the two phases, of phases 1 and 2, we see the difficulties that have been expanded on in detail yesterday by others of separating the issues into two phases, whilst at the same time, of course, recognising that it may be a logistical necessity. And we support, therefore, whatever approach the inquiry concludes is appropriate in order to properly achieve the aim of addressing the issues that you, sir, have already identified. Opening statements. We note that the inquiry team has envisaged that opening statements may be appropriate, and we would hope to make an opening statement at the beginning of both phases 1 and 2, addressing the issues relevant to each phase of the process in respect of each of those statements. Finally now, sir, if I may turn to give you a brief update in respect of disclosure. The TMO support the disclosure process being an open and transparent procedure. The TMO is a paperless organisation. All records are maintained electronically. Immediately following the incident, and with support of the Metropolitan Police Service, an independent digital forensic IT consultancy company was instructed to capture the totality of the TMO's electronic records since its inception in 1995. Within a few days of the incident, all electronically saved records were captured by the consultancy and were provided in their totality to the Metropolitan Police Service shortly afterwards. The TMO has offered to provide the inquiry with a copy of the entirety of its electronic records, but the inquiry has thus far indicated its preference that the TMO continues to respond to the specific disclosure requests as and when they arise. Since the inquiry has started, the TMO has complied with each and every disclosure request that has been made to date, and it has done so within the requested timeframes. In response to a recent request by the inquiry as of the 6th of November, the TMO has provided all records in relation to each individual address within Grenfell Tower and a wider area of the Lancaster West estate as has been specified to us by the inquiry. All of these were provided to the inquiry in electronic form on the 15th and the 17th of November, and they have again been provided on a memory stick that was delivered by hand to the inquiry team on the 28th of November. On the 8th of December, the inquiry team requested that hard copy packs of all of these records for each of the Grenfell Tower addresses be provided to the inquiry by the 12th of January in order to assist the inquiry with its preparations. It's already been confirmed in correspondence to the inquiry that this will be completed in advance of this date as requested. The TMO has also served statements from the head of its IT to explain how documents are managed on the TMO's electronic systems, and from the independent digital forensic IT consultancy to explain how the raw data was captured in the first place. The TMO are committed to their engagement with this inquiry and will continue to respond promptly to all requests they receive from the inquiry wherever possible.
Thank you very much. Would you like to comment at all on the two matters that I invited Mr. Maxwell Scott to comment on? The suggestions that were made yesterday that there might be a consultative panel for the benefit of survivors, bereaved and other local residents, and the suggestion that the inquiry might consider asking for position statements from at least some core participants before we get too much further.
In respect to the first, a consultative panel, it's of course it's an entirely matter for you, but if it opens lines of communication, it would seem an eminently sensible suggestion.
All right, thank you.
In respect of the second, a position statement, not to repeat comments that have been made by Mr. Maxwell Scott of Queen's Council, who's come before me, but essentially our position would be similar. If it is that you would see that to be a sensible way forward, we of course do not object, and we would be happy to provide a position statement. Of course, I've already made a comment on the fact that we would hope, in any event, to make opening statements at the appropriate moment prior to the commencement of hearing evidence of phases 1 and phases 2. My observation would be that in order to make that statement to be full and useful and assist the purposes of the inquiry, and to echo those who've made representations yesterday, we would require meaningful disclosure in order to properly prepare that statement.
All right. Well, that's very helpful. Thank you very much indeed. Now we come now to other core participants who were involved in the refurbishment. CEP Architectural Facades, Mr. Christie.
Mr. Chairman, my name is Aidan Christie. I represent CEP Architectural Facades, one of the corporate participants. I'm instructed by Clyde & Co. And I'm appearing with Mr. Jim Sturman and Mr. Andrew McGee. Mr. Chairman, our written submissions are limited to the issue of expert evidence.
Yes.
We have raised 3 issues. First, the current position of CEP in relation to expert evidence. Secondly, the proposed timetable for expert evidence. And thirdly, the division of issues between Phase 1 and Phase 2 and any consequence of that decision. Mr. Chairman, I propose to make very short submissions to indicate our current position in the light of the remarks and observations which have been made yesterday. And then, Mr. Chairman, I'll pick up on the 2 additional questions which you've been putting to people who have gone before me. Before I go any further, may I say we are obviously aware that these are not adversarial court proceedings. It is for the inquiry to investigate, and we take on board Mr. Millett's observations, both in his written statement and in his remark yesterday, that any party wishing to adduce expert evidence will have to be in a position to show why it cannot be addressed by the inquiry's experts and why it is necessary for that party to adduce its own evidence. Taking our 3 points in turn, Mr. Chairman, without access to the site, our analysis of the expert issues will have to be confined to the documents and a desktop study. That is not satisfactory, but it is obviously unavoidable for the reasons which we have heard. But we will review our position when the inquiry's experts' reports are produced. As to the timing of responses to the inquiry's experts' reports, we welcome the observation of counsel for the inquiry that the inquiry will be sympathetic in relation to those matters. We understand it's proposed there be a further procedural hearing at the end of January, and we are content to wait and see. Our position is that we should be permitted at least 6 to 8 weeks to analyse reports and respond, but we're happy to postpone the issue until January to see what proposals might be made by counsel to the inquiry. Our third and last point, Mr. Chairman, relates to the division of evidence between Phase 1 and Phase 2. We appreciate that Phase 1 is a fact-finding exercise and will be addressing what happened and how, but not why. But we have concerns that there may be some blurring of those distinctions and that expert evidence may stray into an analysis of the why. We simply draw attention to the point at this stage because it may be we'll want to raise the issue when we've seen the inquiry's experts' reports. But we support the observations of Mr. Maxwell Scott that some clarity would be very helpful in relation to the distinction. Mr. Chairman, I assume that you want me to comment on the 2 additional points.
Well, if you have comments you'd
Yes.
like to make, please do, yes.
We take a neutral position in relation to the consultative panel.
Yes.
In relation to position statements, our view is that it's premature, that we shouldn't be required to put in a position statement until certainly we have disclosure, until we have the experts' reports, and until we know more about the issues which we have to address. But, Mr Chairman, we are perfectly happy, obviously, to make an opening statement in relation to Phase 1. Those are my submissions.
Thank you very much indeed. Now, next on my sheet is Mr. Antrobus for Max Fordham, but I understand, Mr. Antrobus, that you may not wish to add any oral submissions. Is that right?
That's right. We don't have anything to add for the submission.
Right. Yeah. Thank you very much. Mr. Catchpole.
Good morning, sir. My name is Stuart Catchpole. I am instructed by DAC Beechcroft on behalf of Ryden Maintenance Limited. As you're aware from our written submissions, we don't seek any specific directions at this particular meeting. We would, however, wish to make some short, mainly responsive submissions to the matters that were addressed to you yesterday, and in particular the submissions made obviously by those representing all of those affected by this tragedy. If those submissions could be summarised shortly, and I will no doubt not do them justice, as I understand it, they were to the following effect, which is that the inquiry must be fair and must be seen to be fair. Ryden agrees. And that applies as much to those affected by the fire as to those who are also appearing in front of you and the individual witnesses who will be called to give evidence on behalf of the corporate and institutional core participants. With that introduction, I, with your permission, would seek to deal with three topics. The first is the engagement with those affected by the fire by the tribunal. And the second is disclosure, and the third is a broad ragbag of case management experts and the Phase 1, Phase 2 split. You were addressed, and if I may say so, eloquently and at length yesterday in relation to the desire of those who have been affected by this tragic event to have a greater interaction with the inquiry process, to have their individual and collective voices heard, and to have their concerns raised publicly, and to have those concerns considered fairly. And fair in this context, as I understand it, is in particular the need for their clients to have a reasonable confidence that the person actually, or persons actually considering their concerns, has a genuine appreciation of the circumstances in which their lives are conducted and can see things from their very diverse perspectives. To the extent that it assists, Ryden agrees. And that's not just on behalf of Ryden, the company, it's the legal team who have represented Ryden, have much experience of public inquiry work. It's fair to say almost all on behalf of institutional or corporate clients. But it is a feature, rightly or wrongly, of a number of inquiries that the victims or a substantial body of the victims feel as if they are disenfranchised. They feel as if they're marginalised by the process and that the things that really touch their lives aren't given proper consideration or aren't properly understood. I say rightly or wrongly, but it is clear that's happened from the Taylor inquiry in which I was involved back in 1989, right the way through. It is inevitable, given the range and nature of the issues with which this inquiry is concerned, that those feelings and those concerns on behalf of those affected are going to be voiced in an acute form. And we would respectfully suggest that they are real, legitimate, and however you do deal with it, they need to be addressed. You've raised with others the need for a consultative panel as an approach. We would suggest that the right way is actually interaction with those representing those affected, but anything that can be done to instill greater public confidence in the outcome must be a good thing. I would, however, note, first of all, you are unlikely to make everyone happy. Secondly, that fairness also demands that to the extent that any of those concerns are matters which are going to be raised in this forum, then proper notice needs to be given to those other call participants who might be affected by those concerns and would need to respond to them. And I will return in a moment, if I may, to some short observations on the implications for the management of the inquiry process. The second topic was disclosure, and that was split into two different aspects. The first is a call for greater transparency and scrutiny of the inquiry's disclosure process, the requests and the responses. The second is actual disclosure of documentation. In relation to the call for transparency, once again, Ryden agrees that it would be appropriate for there to be greater transparency and scrutiny of the disclosure process. It's both fair and, if properly managed, it's likely to lead to the early identification of gaps in the evidence that you will need to consider. I say, however, that it not only applies to those affected by the fire, it applies to all call participants. It goes without saying that, with respect to those represented by counsel who you heard from yesterday will be able to identify gaps in disclosure that they believe exist. My clients will be able to identify other gaps that we may think may exist in disclosure, just as others will look at, no doubt, ours in due course and say the same thing. I would add that, as you're aware, and as others have said before me on behalf of this side of the alleyway, Ryden has cooperated fully with the police and with the inquiry. And I know, sir, that you are aware in particular there's been active cooperation with your team by Ryden and its solicitors, not only to gather and provide to the inquiry all of the evidence that they wish, but to do so in a form that is comprehensible and usable. And that has been ongoing for a number of months. It's been a very substantial task. I know that, but the victims don't. And I would suggest that public confidence can only be increased if, in some manner, a procedure can be adopted to allow them to see and to test what has happened. We very much doubt that that requires all core participants, or indeed even some of them, to be involved in the nitty-gritty of drafting requests, scrutinising drafts before they go out, or things like that. It's very much a process to give confidence in what has gone on and to identify areas which you may consider are necessary to investigate further. That leads me to actual disclosure. We would have thought it almost goes without saying that, as a matter of principle, core participants should be entitled to disclosure of potentially relevant documents in sufficient time to enable a proper and informed review of that body of evidence. That is the only way they can contribute meaningfully to this inquiry process. But that is subject, we would suggest, to two caveats. The first is there was a suggestion yesterday, I believe at least, that disclosure should commence immediately by the inquiry, even if that means that it should be given in an unstructured, or I think the phrase was chaotic fashion, because that is the inevitable consequence of an inquiry. We would strongly, very strongly, caution against unstructured or chaotic disclosure. Many of us have seen the effects of that approach in different forums, and including in public inquiries. In the VSE inquiry, for example, an approach was taken, for understandable reasons, to disclose documents almost as soon as they were received by the inquiry and someone had checked for potential relevance. It made it impossible, and I can say impossible, for anyone meaningfully to get on top of that evidence in an efficient and economic way. And I was representing one of the institutions who we're often accused of having deep pockets. For those that do not have deep pockets, it's inevitable that there will be significant wasted expenditure being sent down blind alleys, and I would suggest an inability properly to digest and assist you at the end of the day. It's not, and even putting aside, as a second aspect, the legal question of whether Article 2 requires complete disclosure of every document to every core participant, a matter on which there's plenty of law, and I've no doubt you'll have it in mind. We would suggest it is not the function of the core participants, any of us, to duplicate the inquisitorial task of the inquiry team. We are here to assist you in resolving the issues within your terms of reference. And we would suggest that disclosure to core participants has to be made in a logical and structured manner. It has to be managed in a way that is fair to all participating in this, and I fully appreciate what those affected by the fire are saying, that they do not have access to as much as anyone else, and steps need to be taken to address that. But it has to be done in a way that actually allows you, sir, to progress this inquiry in the way that you ultimately determine is appropriate, and which allows you and your team to actually do the task that you've been set. And that task, with respect, at the risk of stating the obvious, is to deal with a vast number of issues in a reasonably short period of time. And that is not a process that is amenable to however many lawyers sitting around these tables scrutinising 270,000 odd documents. It's just not a sensible way of proceeding. We will be here for years. That really leads neatly into my third general ragbag area of case management. If I may say so, there was a concern, at least on our side yesterday from some of the submissions, that we were focused on some really important issues for those affected by the fire. But with respect, we should not lose sight of the fact that at the end of the day, this inquiry will have to deal with a vast quantity of potentially relevant documentary evidence, and will have to consider multiple expert reports covering complex and possibly not particularly clear technical issues. Even if one assumes that the 270,000 documents mentioned by Mr. Millett yesterday contain an element of duplication or some which are not relevant, although hopefully that is not the case given the work the inquiry team have put into disclosure, one is certainly makes an educated guess that you are facing hundreds, possibly thousands of lever arch files of documents. And these are documents which have already been filtered for relevance. Now, reviewing, assessing, and making determinations on that evidence is a very, very substantial undertaking. If you add into that the task of taking overlapping, complex expert evidence, which in itself, from experience, is a very substantial undertaking, this inquiry faces a very formidable task. And the marshalling, analysis, and determination of the issues arising out of that expert evidence requires, in our submission, a particular skill set. Whether we like it or not, it is a skill set that lawyers and judges possess. That is what we are trained to do. And while we make no submissions as to whether or not the panel should be expanded, it's not appropriate for us to do so, we do suggest that one of the considerations which needs to be given proper weight in determining whether that should happen is the need for any panel member to be able to do justice to the substantial task that is faced by this inquiry. It is not an inquiry like the Taylor inquiry. That was largely about factual evidence with one technical issue, which is about a safety barrier. This is not that case. The third area of case management is the case management by the inquiry, and I hesitate to make observations on this, but we would suggest that cases of this magnitude inevitably have to be proactively managed by the tribunal. It's simply impossible for them to be effectively and fairly managed if free rein is given to any core participant to engage in the process, to cross-examine in an overlapping manner. I would respectfully suggest, but it's a matter for you, that a procedure that's akin to an inquiry procedure, where everyone gets a chance to cross-examine on multiple evidence, is unlikely to assist in actually distilling the issues. It's unlikely to assist in narrowing expert issues. It is highly likely to add to the confusion of the matter, and it is highly likely to be unfair to at least some witnesses who will receive multiple cross-examination by different parties. And that is precisely why one assumes that a decision was made to make this inquiry an inquisitorial process. And at the end of the day, as the others have said, that is what should be respected. And we are here to help you achieve that aim as best we can. That is not to say, however, that the inquiry should not receive and listen to carefully applications for specific targeted cross-examination from interested corporate. Of course they should. It's a basic premise of fairness. In terms of the expert process, I echo what has been said by many across this room. First is that the timetable that was suggested by the inquiry for the review of the inquiry's expert evidence was simply too short. It is impossible to do that job properly. Secondly, should those affected by the fire have access to expert evidence, hopefully properly marshalled and coordinated? Of course they should. Anyone who does these sorts of cases knows you need to be informed by your experts, because that's the only way you can make meaningful contributions. But hopefully properly managed, not multiple experts, limited number of course they should. Thirdly, should the process be left to disclosing the inquiry's expert reports and then inviting those who want to put their own experts forward to come in and get involved? In my submission, no. Experience suggests that many technical issues can be resolved if you are involved early enough, and if we can make suggestions through the inquiry team as to what further inquiries the inquiry experts ought to make, and to actually identify assumptions they may have made and have them tested. To that end, not only does some disclosure need to be given, but one would think that there is evidence that could be disclosed to all of us now, the video footage of the night. If there are records, as there must be, of the experts visiting the site, given we cannot, they should be disclosed. They should be uncontroversial. Photographs taken by the experts with sensitivity, for obvious reasons, should be capable of being disclosed. The ability to see any tests or forensic examinations that they are undertaking, not to participate, to observe and then feed back through the inquiry. All of those things are likely to lead to a more effective process for you at the end of the day, and are likely to lead to a narrowing of the issues. That leads into the final point on which I would wish to address you, which is phase one, phase two. Clearly, there are difficulties in the split. Clearly, there is an imperative to get on with something. We would suggest, again from our experience, that having effectively a provisional timeline of the events of the night relating to the fire, ignition and spread, and to the smoke penetration through the building, together with the evacuation, is inevitably a baseline against which this inquiry will proceed. And it shouldn't be fixed. There may be things that come up in phase two, but having that document coming out of phase one, and any recommendations that you see fit coming out of, has got to be helpful, because it focuses everyone's mind on facts which are either not controversial or identifying those facts that are controversial for the purposes of phase two. Those were my submissions. I anticipate you were going to ask me about a position statement, and our position is quite clear, and it really reflects what I've said before. Fairness demands that if people are going to be subjected to potential criticisms, then they should be given notice of it. That's the point at which they should be invited to respond. We, like other core participants, would wish, I suspect, to put in opening and closing statements on the phases, but the bottom line is that any core participant who may be subject to criticism should receive a letter of warning before that and have adequate disclosure in order properly to defend themselves.
All right, thank you very much indeed. Now, next on my list is Mr. Riley Smith, but I think maybe you don't actually want to make oral submissions, is that right?
I'm in the same position as Mr. Hammond. I'm very grateful for the opportunity. I have nothing for written submissions.
Right. Thank you very much. That's splendid. All right, thank you. So we now get to Mr. Walsh, who's here for the LFEPA. Yes, Mr. Walsh.
Good morning, sir. Stephen Walsh, I represent the London Fire and Emergency Planning Authority, the LFEPA, which runs the LFB, together today with Sarah Lefebvre. Sir, you, I know, have now read our written submissions and understand them, and all other core participants have seen them, so I have no intention of repeating them today. What I now have to say focuses on the submissions of other core participants, many of whom have expanded on them yesterday. And in short, the LFEPA agrees with certain of the views expressed by those representing the bereaved, the survivors and residents who lived in the vicinity, on the question whether Phase 1 can realistically be restricted to the factual narrative only of the 14th of June, to the exclusion of what many have called the why questions or the qualitative questions. And so while we accept entirely and understand, given the enormous task which the inquiry faces, your pragmatic reasons for proposing a limited-natured Phase 1, we do feel strongly that there are good reasons for giving more flexibility, and perhaps very considerable flexibility, to Phase 1, so as to allow a consideration of the reasons why the LFEPA personnel carried out their fire and rescue operation during the fire in the way in which they did, the application of high-rise fire and rescue policies, many of which have national application, and how they were applied on the night, and obviously the enormous challenges which the emergency services faced in the course of this unprecedented fire. Some of the reasons for adopting a much more flexible approach at Phase 1 have already been touched on by the lawyers for the bereaved and the survivors and residents. But from the LFEPA's point of view, they include, first of all, a strong belief that the bereaved and survivors are entitled to gain an understanding of how and why the fire rescue operation was conducted as it was, as soon as reasonably practicable. And that's the paramount reason. But there are other reasons. The second is that firefighters and others who give evidence should, in fairness to them, have an opportunity of explaining not only what they did, but the reasons why they did it. That, in part, would avoid, where possible, not always possible, we accept, the need for witnesses, many of whom continue to be profoundly traumatized by their experiences, to give evidence on more than one occasion, which I know is an aim that everybody wishes to achieve if that is possible. But it goes beyond that, because if what might be regarded as obvious why questions, the elephant in the room, which one of the lawyers yesterday touched upon, are not to be recognised and not to be asked at Phase 1, the answers to them will inevitably be left hanging in the air, debated in the public arena, possibly for several months pending Phase 2. And the problem with that is that there is a real risk that public confidence in high-rise fire and rescue operations will be unnecessarily affected, possibly through misunderstandings, when clarity is capable of being achieved on certain issues by addressing quantitative evidence, the why questions, at a relatively early stage. And it goes without saying that the extraction of fire safety critical learning and any need to change policy obviously should be done as soon as possible. And it occurred to me actually yesterday that the risk identified by Mr. Westgate, that expert reports at Phase 1 may carry something of a lower status than those at Phase 2, by reason of the fact that Phase 2 reports will address qualitative issues, will be substantially ameliorated. It's not a major issue, but it is another concern. And so I say that because, frankly speaking, the LFEPA at one stage believed that a full understanding of what went wrong with the structure of the building, which we say must have been the case, so as to create such an unprecedented fire, was necessary in order fully to appreciate the way in which the fire service conducted its fire and rescue operation. That remains true, but the LFEPA now feels that the inquiry can properly proceed at phase 1 on the basis that a great many questions will obviously need to be left until phase 2, but questions which can be addressed at phase 1 without prejudicing the police investigation, which is obviously of paramount importance, should be answered as soon as possible, which is, in short, are the reasons why we urge upon you, sir, a very flexible, potentially very flexible approach to phase 1. Whether one calls it phase 1 or phase 2, those are our submissions on that issue. There are only 2 or 3 other brief matters that I want to touch upon. First of all, disclosure. Lest there be any doubt, and so as to be entirely clear, the LFEPA is and always has been, not only in this inquiry but in other instances, fully candid and frank and open in its duty to carry out proper disclosure. And certainly in relation to this inquiry, I hope that we have discharged that duty fully. I know that you are to hear from the Fire Brigade Union shortly, and I simply want to support the Fire Brigade Union suggestion, and indeed that of others yesterday, that the inquiry really would benefit from the assistance of a suitable expert in the application of the Housing Act 2004, particularly Part 1 of that statute. Whether it's a housing officer or an environmental health expert, the LFEPA have no particular comment, but great benefit can be derived from that. Position statements, which I know say you've been asking everybody about this morning. The LFE's basic position is that we can see the merit in the production of written clarification of the LFEPA's position, if only because it might properly reflect what will, in any event, be contained in an opening statement in due course, which all core participants, of course, have a right to make. However, such written clarification as might be provided, whether in a position statement or another document, can really only properly be made at a point when core participants are cited on a significant element of the disclosure which the inquiry will be having to look at. In short, it can only be as good as the disclosure on which it is based, and if any precedent or authority is required for that assertion, the same question was addressed in the renewed Hillsborough inquests, and the coroner, former Lord Justice Goldring, took that view. In other words, that we should be further down the line with more substantial disclosure before position statements are appropriate. But that is not to say that the LFEPA doesn't want to do it, because we're very anxious to get to do it and get on with it as soon as possible. Remembering that it is the Metropolitan Police who are responsible for taking statements, and that includes all statements from firefighters and LFEPA personnel, the vast majority of which are obviously yet to be disclosed. And on that topic, finally, we would expect the LFEPA to provide its written opening statement to the inquiry for appropriate disclosure well in advance of the hearing of live evidence. And then finally, since so you've been addressing the question of a potential consultative panel, the LFEPA certainly has no objection to that course and can well see why such an approach could be very beneficial for many reasons. So those are the short submissions that I make. I don't know if there's anything else.
No, that's very helpful. Thank you very much indeed.
Thank you, sir.
Now, Mr. Seward. All right.
So I'm Martin Seward. I'm instructed by Gerard Stilliard of Thompson's, and I'm counsel for the FBU. The FPU is the largest trade union in the fire service, and it represents firefighters nationally. In London, over 90% of uniformed staff are members of the FPU. Easily over 90% of the firefighters who attended on the night of Grenfell Tower were FPU members. The FPU has a statutory health and safety role for firefighters and appoints safety representatives. Following the Grenfell Tower disaster, the FPU is conducting its own investigation by a safety representative, Stephen White, alongside the police and the LFB, and he will report its findings to the GTI team in due course. There will be much agreement, and the FBU report will deal mainly with issues where there's a difference of opinion, trying to avoid overlap. The scale of the Grenfell Tower tragedy needs no hyperbole. The FBU has from the start argued that the victims, the survivors, the residents and the bereaved should be placed at the very heart of this inquiry. The FBU supports their call for a panel to broaden diversity, whilst understanding that you can't appoint one, but you can recommend it, and that panel to reflect the Grenfell Tower community. The FBU supports the need, if at all possible, for a subsequent string of coroner's inquests to be obviated by the GTI addressing all relevant questions and applying Articles 2 and 14. The FBU supports the pleas for early and rolling disclosure of generic documents, such as those listed in the FBU's submissions, and likewise support a venue closer to Grenfell Tower, if that's possible, to encourage greater participation, and funding for experts to enable core participants to participate effectively. The FPU also agrees on a procedural point that position statements, there's no need to duplicate them. They can come with opening statements. They are effectively the same thing. Moving on, firefighters are victims too. Firefighters who attended the Grenfell Tower disaster and control room operators up and down the country who took those harrowing calls are victims. They were exposed and re-exposed to trauma as they went back in again and again. They were, in fact, placed in an impossible position, and they should never be placed in that impossible position again. The FBU's knowledge and experience of earlier fire fatalities shows that nearly all the firefighters who were there will have been traumatised, and that some will be injured by that trauma. It's still too early to say in many cases. In the military, as in the fire service, late onset PTSD is becoming a recognised condition. There are clear parallels between the firefighters and the residents, survivors and bereaved. Firefighters are victims and survivors, as I've already said, of the Grenfell Tower disaster. Firefighters are, importantly, a community of working people who reflect the diversity of the Grenfell Tower community and the public that they serve up and down the country. Importantly, and perhaps you may not appreciate this, sir, but firefighters feel that their voices have not been heard by the fire service establishment over the last 15 years of deregulation, cuts and closures. Moving on to the next procedural point, Mr. Millett has described one procedure for getting evidence from resident survivors and the bereaved, and a different one for firefighters, so that firefighters don't have the opportunity, under the present arrangements, to call for disclosure of documents and give a statement to their recognised legal representatives, but instead they must rely solely on their police statement. We're in the dark at present about what may have been said in their police statements. We did provide a list of additional questions which we hope were put in the course of those interviews, but we don't know if they were in all cases or if they were put, if they were answered. But for the reasons given by Mr. Friedman yesterday, the firefighters too should have safeguards so that where the need arises, and I don't say in every case, because I'm sure that in most cases firefighters will be content to stand by the statement they gave to the police, but where the need arises, that other process can be followed for them as well. There may be a need, for example, to contextualise what they've said, to, as Mr. Walsh indicated, to explain why. I've raised this with Mr. Millett very briefly this morning and will be happy to discuss it with him in due course.
Yes, all right. You envisage what, that the firefighters should have a chance to talk to solicitors about what they've said to the police? Is that
that's the essence of it, the broad thrust of it, so that they might want to have a document pointed out to them, they might want to refer to a document, they might be able to answer a further question. I appreciate that there's an anxiety not to delay the process, and I don't anticipate that arising in every case, but it might arise. So moving on, the Fire Brigades Union wants this Grenfell Tower inquiry to be a success, to gain and to keep public confidence. We've helped the police and the London Fire Brigade to facilitate interviews, and we've provided information when requested. The Fire Brigades Union also wants this inquiry to answer the big question that Mr. Mansfield identified yesterday. So how could this happen in London, where the resources to achieve fire safety in tower blocks and to fight fire effectively should be readily available? Most importantly, the Fire Brigades Union wants lessons to be learned, recommendations to be made, and for those to be acted upon and embedded. The Fire Brigades Union experience of earlier tragedies is that the recommendations are not always heeded. And we've already provided to your team a list of what we perceive to be the relevant recommendations made from earlier inquiries and inquests into firefighter fatalities and other fatalities in tower block fires. And we anticipate providing a witness statement from Matt Rack, the General Secretary of the FBU, to address issue 10 under the inquiry. Accordingly, we support Mr. Steen's proposal that he made yesterday for your inquiry to retain or to implement oversight of the recommendations to ensure they're embedded and implemented. How you do that is obviously a very big question. The coroner's rules were changed to try and do that, but that perhaps you'd be prepared to hear submissions and in due course. Turning to phases, the FBU argued in our submissions for a limited extension of the scope of Phase 1 on the purely fact-finding basis that has been advocated by the team on the cause and spread of fire, etc. We now accept the arguments that were made yesterday and indeed which Mr. Walsh spoke to today for a more flexible approach and early reporting of safety issues as they arise, as indeed has been supported by Mr. Maxwell Scott. We think things have moved on, and importantly, Mr. Johnson's submissions indicate that the police forensic evidence won't be complete until the autumn of 2018, and so inevitably all experts are going to make their reports provisional, and that's going to make it impossible to make final findings of fact at any earlier stage on the cause and spread of the fire. And that leads us to starting now, really, starting quite quickly. So the fire service is predicated on the basis that fire will break out. The precise cause of the fire doesn't concern the incident commander who arrives. He's confronted with a fire, and the fire service is there to extinguish it and to rescue people. And so the firefighting operational side of Grenfell Tower is one aspect of this inquiry which the FBU would urge should be addressed as soon as possible. What none of us want is for an incident commander to arrive at a tower block tomorrow and to face the same dilemmas that they faced at Grenfell Tower. If I can move on to the need for an independent environmental health practitioner.
Yes.
I think there's quite a lot of support for that, but just to underline it, in our application, sir, we asked for such a person to become an assessor. In view of the submissions made by Russell Cook, Mr. Arden and Mr. Bates, and argued orally yesterday by Mr. Bates, we would accept their position is more refined and better serves the purpose we're trying to achieve, which is to have a tenant representative as an assessor and to have an independent environmental health practitioner as an expert for the GTI team. So that's if I may orally amend our application in that regard. As matters stand, sir, there's a very important part of the fire safety regime for tower blocks like Grenfell Tower, which is wholly outside of the scope of this inquiry, which is Part 1 of the Housing Act 2004. And there is a little known and little understood safety regime called the Housing Health and Safety Rating System, HHSRS, I think is how it's supposed to be pronounced, and that is currently being overlooked. No questions are directed to that scheme of any of the experts, and it doesn't appear in any of the lists of issues. At the moment, the focus is perhaps erroneously on the fire safety order. I say perhaps erroneously because obviously that's a matter for you to consider in due course. But may I direct you to paragraph 9 of our third submissions, where I set this out in some detail. And if I can just summarise it, the HHSRS is the only fire safety regime which expressly includes the structure and exterior of buildings like Grenfell Tower. And so it's an important part of the fire safety regime that really should be looked at. And also an expert would be needed, not only to do that, because the HHSRS is quite complicated. It's real expert territory. But also, if we're going to have proper and effective recommendations going forward, we'll need an expert's help to formulate those. As to the tenant's representative, we do adopt what the Russell Cook submissions said, paragraph 7 and 9. Can I just add, though, what the FBU calls the establishment point? And this is that, as currently constituted, leaving the academics to one side, because everybody understands they're academics and they have their own field of expertise and they get on and do what they're best at. But the inquiry team currently has a firefighting expert, Steve McGurk, and 2 assessors, Joyce Redfield and Joe Montgomery. And all 3 of those are or were high-level managers. And they were all, possibly still are, close to local and central government. And if we add to that mix the fact that Steve McGurk and Joyce Redfield are both deputy lieutenants in the county of Greater Manchester, then it emphasises and reflects the gap between them and the Grenfell Tower community, and indeed the ordinary working people in the Fire Brigades Union. And so this can be remedied. It can be remedied in a number of ways. And if we have an environmental health practitioner expert for the team, if we have a tenant representative assessor, and if there's a consultative panel, and if a fire expert is appointed to assist the team, who hasn't been so closely involved with deregulation and cuts as Mr McGuirk, then greater confidence would be established in the inquiry. If I can move on now to Mr McGuirk. The FBU does not question his expertise, his seniority or his experience. And we quite understand why he seems to the Grenfell Tower inquiry team to be the perfect expert. But we do ask you to listen to our concerns and understand why we are persisting with our concerns. We don't believe that Steve McGuirk is the appropriate fire expert to assist the inquiry. Firstly, he's been at the forefront of deregulation in the fire service from 1999 to 2015, the period when he was a Chief Fire Officer. He has been a champion of the change and transformation that's taken place in the fire service, and that has led to cuts and closures in reliance on statistics showing a fall in domestic fires and fatalities. During that time, he was a board member of the Chief Fire Officers Association for over 7 years, and he was its president from 2006 to 2008. The Fire Brigades Union has opposed those changes all the way along, and Mr McGuirk has consistently been at the opposite end of the table to the Fire Brigades Union. I asked Matt Rack yesterday if he could remember any single occasion in which Stephen McGuirk and the FBU agreed on an issue, and he was unable to recall. That might, of course, reflect his poor memory. It might reflect the fact that that Mr McGuirk and the FBU have traditionally and still oppose each other. Certainly that is the perception the FBU has.
Right.
Significantly, the FBU wants this inquiry to consider the effect, if any, of deregulation and closures and cuts on the emergency response of the 14th of June 2017. And that is part of investigating the big question, how could this happen in London? And we contend that Mr McGuirk is inevitably conflicted in considering or advising the team on that issue. Furthermore, he's been the principal advisor to the Local Government Association in the production of their fire safety guidance. The fire safety guidance has been contentious from the outset. But crucially, it was unamended following the recommendations in that regard made by the coroner after the inquest into the Lakanal House fire. And so we take the view that Mr McGuirk is conflicted and would be unable to help the inquiry on several of the issues that have been listed: 10B, 10C, 10E and 12E. For example, he was in charge of Greater Manchester Fire and Rescue Authority when the recommendations were made by the coroner from Lakanal. And one question for your inquiry will be whether those recommendations were implemented in London adequately. And Mr McGuirk, I suggest, is compromised in that regard. He's unlikely to be critical of any such implementation that broadly mirrored what he did in Manchester. He has a duty of impartiality and independence, which the team have rightly acknowledged, and he's got to be seen to be both impartial and independent. The FBU fears that instinctively he'll strive to show that deregulation, cuts and closures were irrelevant to what happened at Grenfell Tower. The FBU suggests that the team could use another retired Chief Fire Officer, preferably from Scotland, who hasn't opposed the FBU throughout his or her time in high office. I've made some specific points about the letters of instruction to experts in the submissions, and I refer you to our supplementary submissions, paragraphs 8 to 15.
Yes, I've read those.
Unless you want to ask any particular questions about them, I propose to move on.
It's probably all there, isn't it?
It's all there.
Unless you want to expand on anything.
I don't.
No. All right.
It's all there. Thank you, sir. If I can take you to the application, then, the FBU is applying for the termination of the appointment of either or both of Mr McGurk as an expert or Mrs Redfern as an assessor. We are grateful that the inquiry team have made their checks and are satisfied of the integrity of both, and we accept that, obviously. But this is a process that's got to be transparent, and justice has to be seen to be done. The FBU's reservations remain. Paragraph 3 has been amended as I'd indicated, so it's the appointment of an assessor who's a tenant representative and an expert who's an independent environmental health practitioner.
All right.
And thereafter, if Mr McGurk stands as an expert to the inquiry, then the FBU would ask for permission to instruct an expert in operational firefighting so as to peer review his evidence. And the FBU
Would it be sensible for you to see his report before that's taken any further?
It would be sensible, yes, certainly. And of course, the reason I'm raising it now is because the FBU can't afford to fund that expert. That expert would have to do a lot of reading and a lot of work, and that would all cost money. And so an application for funding will be made. I believe that's already underway. But the FBU is a non-profit making organisation. It doesn't have a budget for this sort of commitment. And the sixth application, I can leave that until a later stage.
Yes, all right, thank you.
So, unless I can help you any further, sir.
That's very helpful. Thank you very much indeed.
Thank you.
Now, I've... sorry, give you a chance to sit down again before I... although I think on your running sheet, Mr Beer comes next, I've slipped into my running sheet and note that Mr Brown, who's instructed by the Fire Officers Association, is here. And would you like to make some submissions? Yes, of course.
Good morning, sir. I am Louis Brown. I'm instructed by Jonathan Wall of Burton Copeland Solicitors on behalf of the Fire Officers Association. The Fire Officers Association, the FOA, has a current membership of around 1,200 and represents mainly those in middle management roles. It is one of the two nationally recognised unions for fire and service personnel. Whilst we, of course, represent the interests of the union as a whole, our particular focus at this stage is on two of its members, Richard Welch and Lee Drawbridge. Richard Welch is the borough commander for Lambeth, and he arrived at Grenfell Tower shortly before 2 a.m. on the night of the tragedy. He assumed the role of incident commander He designated the fire as a major incident. The role of sector commander was performed by Deputy Assistant Commissioner Lee Drawbridge, and Mr. Walsh was then appointed fire sector commander, a role which he held for about 10 hours. It was his duty to constantly reassess the incident as it developed, the formulation of strategies, and the deployment of resources, including firefighters. Mr. Drawbridge was tasked with the duties of sector commander, command support, and he remained at the scene of the tragedy until about 4 p.m. that day. Can I briefly say a word about collaboration, please? We will look to collaborate closely with both the London Fire Authority and the Fire Brigades Union, wherever possible, with both of whom we share many common interests, and we will cooperate with them in a manner that will avoid the duplication of work, resources and time. Can I then deal, please, with some discrete issues?
Yes.
Disclosure. We adopt and repeat all that has been said on that. We would respectfully seek a disclosure in a structured manner as soon as reasonably practicable. Broader issues of disclosure, we agree with Mr. Seawood and the position he sets out in paragraph 11 of his written submissions. And we would welcome the use of the relativity platform, with which my instructing solicitors have considerable familiarity, given its usage at the Hillsborough inquests. So far as the structure of the inquiry is concerned and the phases, we would respectfully adopt entirely all that was said by Mr. Welsh, Queen's Counsel, on behalf of the London Fire Authority, and in particular the vital need for Phase 1 to include the ability of firefighters to deal with the rationale for their decision-making, in part the stay put policy. So far as the questioning of witnesses is concerned, looking farther forward, so we agree that proposed questions, prepared questions, should be submitted in advance, but would ask, please, that appropriate flexibility be given in due course. So far as written statements are concerned, we adopt and repeat what was said by Mr. Seawood insofar as any supplemental witness statements of key witnesses are concerned. And finally, can I also say we share and endorse Mr. Seawood's submission that both firefighting unions will do everything within their power to ensure that your inquiry answers the questions that demand answers, unless I can insist further.
That's very good. Thank you very much indeed. And I think it is Mr. Beer's turn. Can you make your way out of there, Mr. Beer? All right. Yes.
It's Jason Beer, representing the Secretary of State for Communities and Local Government. I had indicated to Mr. Millett that I didn't intend to say anything, and indeed I don't intend to speak to the two-page document that we submitted, given conversations that I'd have with him and the submissions that he'd made yesterday. It's not necessary to do so. Can I just briefly, therefore, address you and try and assist you on the two supplemental issues that have arisen?
Yes, of course.
And that you've been putting to other advocates. Firstly, then, a consultative panel. If such a panel encourages the opening of lines of communication and a dialogue between former residents, the relatives of the bereaved, and survivors of the disaster, and if it allows dialogue outside of the formality of hearings such as this, it has much to be said for it, in our view.
Thank you.
As for position statements, we do not object in principle to the service of position statements. But when you're considering the request that's been made to you, we would respectfully ask that you bear in mind the following 3 points. Firstly, of course, these are inquisitorial proceedings, with you as the Inquisitor-in-Chief. Pleadings, of which position statements are a species, are not a feature of such proceedings for good reason. And that may be why they've not hitherto featured in any of the approaching 24 inquiries established under the 2005 Act, in which the 2006 rules apply to.
But could they not be helpful in clarifying the ground for the benefit of all core participants and others?
Of course they can, and it will be within your Section 17 power to require them. And I'm going to suggest the potential solution in a moment, and this is the run-up to the wicket, effectively.
Right.
Second, an element of realism needs to be brought to bear to the exercise, because the application is made on the basis that the statements will help to narrow the issues and therefore save time and cost as one reason for them. But this inquiry is very much multi-party. And there are no parties, of course, but in litigation equivalent, it's supercharged multi-party litigation. And there, of course, where what CP number A says about an issue is not going to bind CPB. And so the likelihood of being able to take things completely off the table is perhaps more illusory than real. The third point, as others have said already, is that if position statements are to have value and meaning, they must come after disclosure and expert evidence. Indeed, that was one of the reasons why Sir John Goldring, in his ruling, you may look at it at your leisure, it's paragraph 25 of his ruling, refused the equivalent application that Mr. Weatherby made in the Hillsborough inquests. Of course, that was slightly different. The application was made whilst the inquests were on foot, so we were part way through them. But what he said was, I couldn't have ordered them before we started at one of the pre-inquest hearings because there hadn't been disclosure or expert evidence at that stage. And so a potential solution, in particular where you're operating necessarily under a compressed timescale, and therefore there isn't going to be the luxury of building in additional time to allow people to pause for thought, consider all of the disclosure they've got, and file a position statement, is to give directions as to the content of Rule 10 opening statements. Normally parties, core participants, are allowed almost a free rein as to what they may say. But you could, under your Section 17 powers, give directions as to the contents of them and make that the occasion on which parties must, in relation to a series of identified issues, set out their position with clarity. And that's the solution that we would respectfully propose. So that's all I intended to say.
Yes, well, that's helpful. Thank you very much indeed. Now that you've been very economical in your use of time, I must say, all of you. That completes the list of those who I have who are expecting to speak on behalf of core participants. Can I just check there's no one here who thinks he's been overlooked or she's been overlooked because there's something you needed to say? No, right. Thank you very much. Well, in that case, I'll invite Mr. Millett to respond to the various submissions we've heard. Yes, Mr.
Just 2 points. I think in fairness to Mr. Millett, before we speak, that we would like to clarify, so it's not additional.
Well, would you like to come and clarify it from the place where you can be seen on camera?
Thank you very much. I'm very much obliged for this opportunity, and I think my learned friend Fiona Murphy also wishes just to do this. I'll do one point. She has another point relating to our submissions. The point I just wish to clarify, as far as I'm concerned, is the one that you raised with me yesterday. That is the question of a consultative panel. I think I answered it, but in case there's any ambiguity in what has transpired,
We maintain the position, and it's only because the word panel crops up twice, that there should be no confusion that a consultative panel is no substitute for a decision-making panel of which we are advocates. And may I just say, I think that makes the position clear. Don't see anybody query.
If it's any comfort, Mr. Mansfield, there was no ambiguity in my mind about your submissions.
Well, I'm very much obliged.
But I thought it right, given the particular nature of any consultative panel representing the views, if you like, of the bereaved, residents, survivors and so on, that those who are core participants but not of that body should just have a chance to say whether they saw any objection to that course if we thought it right to take it forward. And I'm grateful to them for their assurances that they see no objection to that. And that was the reason I raised it.
I'm very much obliged. The final matter on this is that I think I can only speak for the ones I represent. We would need an opportunity to consult with our own families about that particular concept, but I can't take it any further at the moment.
Well, it's an idea that had occurred to us and that we are thinking of taking forward, but it won't happen without consultation.
Much obliged. Thank you.
Yes.
Thank you, sir. I'm instructed by Mr. Jangir Mahmood of Bishop Lloyd Jackson Solicitors, led by Mr. Weatherby, who apologises as he's another professional commitment today.
All right. Yes.
I have two topics that I wanted to respond to very briefly, sir, both arising from the substantive focus of our submissions. And the first is with regard to position statements, sir. And can I ask you to consider our short paragraph, paragraph 16, in which we set out what we consider to be the appropriate content of the position statements. And what we say there is that it should set out the party's position as to what happened and what failures, if any, they acknowledge as falling within their responsibility. So we say a concise but precise form of words there as to what is envisaged, and we emphasise the importance of that being endorsed with a statement of candour. And with that run up to the wicket, as Mr. Beer would put it, we would support his suggestion that that be addressed by the means of a direction in the context of the Rule 14, I believe it is, directions with regard to the opening statements. But it's important to appreciate, sir, that they are different animals, and we don't agree that their value is more illusory than real in situations in which one party is not able to bind another party. Because the statements, not only are they very meaningful for the families to hear, for the bereaved and the residents, and those affected by the disaster more generally, it's also the case that it will assist your inquiry as to how the inquisitorial process is focused. And it may be material that each of the state core participants appear to support the making of position statements, which is perhaps significant progress that is learning that has arisen from the Hillsborough inquest. And clearly, if Mr. Catchpole does wish to advise his client not to make one, then it's our proposal that he should give reasons for not doing so.
Right.
So secondly and briefly, with regard to disclosure, a topic that has occupied, quite rightly, a significant portion of these hearings. And we would like to emphasise that the specificity of the request that your inquiry have made, and which we've now learned about in the course of these hearings, underlines for us the importance of our request for openness and transparency with regard to the process of disclosure. Everything we've heard has served to further emphasise the importance of that. And in that context, we support Mr. Catchpole's remarks. And we also agree that it's important that the process is structured. And we commend to you paragraph 10 of our instructions, in which we set out in some detail our understanding of how this process should work. And we emphasise there, sir, the three stages, production to your inquiry, disclosure to the core participants, and the preparation of bundles. And it's only the core bundles that will be relied upon in the questioning of witnesses. So we strongly disagree that the core participants cannot scrutinise 200,000 documents. We are experienced, we have that skill set, we've done it before, and clearly it has to be supported with active case management. But finally, on disclosure, we emphasise and agree with a number of the submissions that early disclosure is possible. It doesn't have to be chaotic. We'd much prefer it structured. But as soon as we get started, the better, and the tranche approach is not inconsistent with good management. Thank you, sir.
Thank you very much. Well done, Mr. Millett.
Thank you very much, Mr. Chairman. May I start my very brief response submissions by thanking all the core participants and their advocates for their helpful, succinct and thought-provoking submissions. There is much for the inquiry and for you, Mr. Chairman, to take away and consider carefully. I only want to cover three things in my wrap-up, as it were. First, Mr. Mansfield's formal application for a panel of decision-makers to sit as decision-makers with you. Second, experts, and just to say something very briefly about that. And thirdly, something even more brief about the TMO disclosure of the housing files. So far as the first of those is concerned, Mr. Mansfield's application for a panel, our basic position is this. We recognise absolutely that unless the work of our inquiry is collaborative, inclusive and empowering of those who were the victims of the fire at Grenfell Tower, our work will be in vain. We completely agree with the sentiments expressed by Mr. Mansfield and others about public support for and confidence in the work of the inquiry. It is for that reason, among others, that the residents, the survivors and the bereaved have been given automatic core participant status. That has actually brought them right into the heart of the inquiry. They will get access to the disclosed documents. They will get to make submissions. They will get to give evidence. They will get to pose specific questions and see that justice is done at very close quarters. Core participant status brings very significant advantages. It ensures balance, it ensures thoroughness, and it ensures openness. As I set out yesterday, Mr. Chairman, we do intend to involve the survivors, the residents and the bereaved who are core participants in the process and processes of this inquiry into their tragedy as much as we can, consistently with our duty to control and operate a ruthlessly independent and effective investigation. However, the question of the composition of the panel does give rise to rather different considerations. We would suggest, very briefly, that it is properly a matter for the Prime Minister, as the sponsoring minister, to decide under the Act whether she wishes to appoint other members to sit as decision makers with you on a panel. We would suggest, respectfully, that it would be wrong for you to express any view either way before she has made that decision, since that might be seen as influencing her decision on that matter. And you need no reminding, but I'll remind you anyway, Mr. Chairman, you must remain wholly independent of government in this inquiry. If she decides not to ask you, then the question of your consent under the Act does not arise. If she does ask you, then you must, and you will, approach the question of whether to consent with an entirely open mind. So far as the question of experts is concerned, my second wrap-up topic, there is one important point of clarification on expert evidence that I may need to make. Some of the submissions that you heard yesterday from certain of the core participant advocates, including Mr. Steen, suggested that the inquiry had accepted that bereaved residents and survivors should be allowed to engage their own experts and their own expert advisors. I quote from the transcript at page 121. What, in fact, I said in my oral submissions to you yesterday was that the inquiry team was sympathetic to the need to allow more time for all CPs to digest the inquiry experts' reports and to make any applications to call their own expert evidence than had been indicated in our provisional programme. Beyond that, in terms of whether permission will be granted for any particular core participant to call their own expert evidence, our position remains entirely unchanged from my statement dated the 15th of November, namely that the guiding principle will be that it is for the inquiry to investigate. Any core participant who wishes to call an expert on any particular topic will have to make out an exceptional case as to why they should be permitted to do so. I reiterated that yesterday. Any such application will need to explain why, in the context of an inquisitorial procedure such as this, the core participant should be permitted to call expert evidence, and why the work cannot be undertaken by the inquiry experts or, for example, by putting questions to them. All of that said, we do see force in ensuring as far as we can that there is equality of arms between the core participant organisations, whether between themselves or not, and individual core participants, so far as concerns the assessment of the need to call an expert or the need to apply to do so. And there is, of course, a threshold and preliminary set of work that may need to be done in order fairly to allow core participants to arrive at that position. We would suggest, Mr. Chairman, that we, the inquiry team, give that further consideration. Thirdly and finally, so far as the TMO's disclosure of the relevant housing files is concerned, the position is that the memory stick provided by the TMO on the 28th of November was, I'm afraid, very difficult to access and manage. The inquiry team met the TMO's solicitors on the 5th of December and informed them of the problems such as corrupted documents, duplication, unreadability and other matters of that nature. We wrote to them on the 8th of December asking for hard copies by the 12th of January. Ms Jarrett has very helpfully told us that those will be produced by Christmas, and so this particular problem has, I think, now been resolved, and I'm glad to be able to tell you of that, and we look forward to the TMO's continuing good offices and assistance in that matter as in all others. Mr. Chairman, I have nothing else to add by way of reply. I'm grateful for your attention.
Thank you very much, Mr. Millett. Well, I'd like to thank all of you who've made contributions for those contributions, whether they've been written or oral, or in many cases both. And I'd like to thank you also for being so economical in your use of time, which means we can now draw this hearing to a conclusion. It goes without saying that I've found your submissions very helpful, and in many cases, as Mr. Millett put it, thought-provoking. And for that reason, I'd like an opportunity to digest them and to review the transcript of the proceedings. So I'm going to take a little time to do that. I shall respond in writing as soon as I can, and in any event, I hope by the middle of next week, if not a bit sooner. I'd also like to thank all counsel for the way in which the submissions have been presented. They have been forceful and direct, as one might expect, but at the same time they've been careful and measured, and I'm very grateful for the way in which you've all contributed to the conduct of the hearing. There have been clear indications, as far as I can see, that with the benefit of continuing dialogue, it should be possible to take the inquiry forward in a way that enables the work to proceed as quickly and smoothly as possible, while at the same time ensuring that the needs of all core participants, but particularly those of the bereaved, survivors and local residents, are fully met. And I look forward to seeing you all on another similar occasion before too long. Thank you all very much.